Hello, viewers. Welcome to the Low Mind. Today, we are here to tell you all about Cybercrime Prevention Act in the Philippines. What is the Cybercrime Prevention Act of 2012? Officially recorded as Republic Act number 10175, this law of Philippines was approved on 12th September 2012, which basically aims to prevent the offenses of cybersex, child pornography, identity theft, illegal access to data, and libel. On February 18th, 2014, the Supreme Court upheld most of the sections of the law, including the controversial cyber libel component. And on 9th October 2012, the Supreme Court of the Philippines issued a temporary restraining order stopping implementation of the act for 120 days and extended it on 5th February 2013 until further orders from the court. This is one of the laws in the Philippines which specifically criminalizes computer crime. I means the cyber crimes which are at a pace in these days in the world now, and we must have learned most of the laws, cyber laws, prevention of these laws, like data protection law in India, but we haven't seen what is the world all about. In Philippines, we don't know what is the real case. So today we'll be telling everything about not only India, but today we'll be looking outside India, that is Philippines. What is the Cyber Crime Prevention Act of 2012 of Philippines, and how is it dealing with, what are the advantages, disadvantages of it? Fundamentals of the act. Now we'll be dealing with what are the fundamentals of the act. The cybercrime basically is the use of computer as an instrument to either detect other person's information through email, website, or doing fraudulent activities such as trafficking, child pornography, or stealing identities, or violation of privacy of others by collecting and taking their data illegally. Majorly, cybercrime is an attack on the information of individuals or governments or corporations. Basically, there is a person जो कि वहाँ पे खड़ा रहता है, और वो खड़ा रहता है इन द सेंस कि वो कंप्यूटर के पीछे होता है, और जो कंप्यूटर की दुनिया है, क्योंकि आजकल सब लोग कंप्यूटर से या फिर लैपटॉप इन्हीं सब से डील करते हैं, उनका डे टू डे वर्क इन्हीं सब से होता है. और basically most of the cyber crimes up in India, outside India, around the world are through these digital medias only. Signed by the President of the Philippines, Mr. Benigno Aquino, on 12th September 2012, and the original goal of this act was to penalize acts like cybersex, child pornography, identity. Further, moving on to the key provisions. Number 1, illegal access. What does illegal access mean? Access to a computer or any application without permission. Number 2, illegal interception, which means interception of any non-public communication of computer data to, from, or within a computer system by an unauthorized person. Number 3, data interference, which means unauthorized tampering with, destroying, deleting, or deteriorating computer data or the electronic documents which may be of a government firm or an individual firm or private firm. This provision can also cover authorized activity if the person's behavior went beyond the agreed upon scope and resulted in the damages listed in this provision. Number 4, use of devices. Misuse of devices basically deals with the unauthorized use or maybe the possession, production, sale, procurement, or distribution, or otherwise making available of computer programs or other materials developed for committing any of the acts which are listed in the Republic Act 10175. The unauthorized use of computer password or the codes through which they can access or similar data that allows the entire of a computer system to be accessed with the intent of using it fraudulently, or the any kinds of offenses which are listed in this particular act of 10175. Number 5 is cyber squatting. Cyber squatting means the acquisition of a domain name in bad faith or in the interest to like profit or to harm the reputation and prevent others from registering it. This may also even includes like trademarks that were already registered at the time of registration, names of people other than the registrant, and trademarks that were purchased with intellectual property interests in them. Also, those who get domain names of prominent brands and individuals who in turn are used to domain their reputation and can be sued under this provision. To be noted here is that the freedom of expression and infringement on trademarks or names of persons are usually treated separately. They are not treated under this specifically, but they are treated separately as a separate entity. A party can exercise freedom of expression without necessarily violating the trademarks of a brand or the names of a persons. The advantages of this provision: cybersex, cyberbullying, child pornography are now offenses, and such offenders can be punished under this act. These three cyber problems of children's are being now defined as offenses and would be helping in child's rights protection, because cyber sex and cyberbullying are the prone areas where the youth which is indulged and attracted towards, because the transition from one particular age to another, and the teen age which they are basically dealing with, the youth gets too much attracted to these situations, and if they proves to be fruitful, because these three terms which are very serious matter have now been defined as offenses and would protect children's right. All kinds of businessmen using the internet as a medium are protected by this act. This act protects all the business transactions which the businessmen or the entrepreneurs carried in their day-to-day life. The cybercrime basically gathers the information of the people who are great businessmen or who have daily transactions in crores or millions and billions, and they do fraudulent activities towards them so that they can gain a large amount of money. So it would definitely help businessmen, because they are being going to protected now. Provisions of this act now define the offenses of cyber squatting, and this deters people from the act of cyber squatting. Now, what is cyber squatting now? The cyber squatting is the act of registering or using the domain name to get profit from a trademark or the corporate name which they use for themselves, but it is of the other individual, but they take it as the their personal identity. Basically the fraudulent activity of using others personal name to benefit their own situation. The next is provisions that penalizes online identity theft. This provision protects the individual's privacy and its protection. Disadvantages: now, for every act which benefits something, there are certain drawbacks or loopholes which can be found out. Number one, ambiguity in the terms given in the act, such as the term online libel is not defined anywhere, which can lead to different interpretations. Ambiguity can be seen in the provision of real time data collection. There are always some loopholes, or something which benefits someone may not benefit the other person. There are certain ambiguities, ambiguous sentences or phrases which are used in the acts, which does not defines clearly or interprets what the exact term online libel is. The ambiguity in the act may lead to the freedom of speech. The ambiguity, like the absence of a proper definition of online libel, may lead to confusion. Basically, the proper definition of online libel is not there in this act, and which may lead to confusion, because the interpretation may differ from people to people, and one person interprets it as something while the other person says it is not. The implementation and execution of this act yearly cost a huge cost to the government. The Philippines government really had to incur a great expenditure to for the implementation and execution of this act, because formation of a new act, then processing it, also promoting it towards their native peoples is really a big task for the government, and it needs to be costly, because it's not easy to promote and to pass, implement, or execute these things easily. What was the community response at large? Now, the community potentially told that it would rather affect the freedom of speech and expression of some individuals, but while others, such as Edgardo Angara, the main proponent of the act, defended the law, saying that it is a legal framework to protect freedoms such as freedom of expression. He says that it not only hinders the rights of speech and expression of an individual, but it protects their fundamental right, that is the right to privacy, and not leaking their information out, or is very necessarily to protect the rights of individuals so that they does not get indulged into any cyber crime activities of cyber sex or cyberbullying, such as cyber squatting as well. uh, it protects them from computer related forgery as well, because unauthorized input or a deletion of a computer data which results in inauthentic data with the intent that it be considered or acted on for legal purposes as if it were authentic, or regardless of whether the data is directly readable and intelligible, or the act of knowingly using computer data, that is to the product of computer related forgery is defined here. And so this Edgardo Ingara uh, comes forward to defend this act. Also, this situation, however, is slowly changing as government and international attention is increasing the rate of crime. With the increasing pace of the cybercrime world, the native people and the individuals are getting the importance of this act. They're understanding that this law is made for them, made for their protection, made for the protection of their rights, their fundamental duties, responsibilities, their rights, so that nobody could violate and curtail them. The private industry, particularly the major internet service providers, that is the ISPs, has begun to collaborate on issues of cybersecurity and cybercrime prevention. A question which I would like to ask you all is, will the new cybercrime potentially affect the fundamental rights? A few arguments which I would like to raise is, a new Philippine cybercrime law drastically increases punishments for criminal libel and gives authorities excessive and unchecked powers to shut down websites and monitor online information. So the new cybercrime law upholds to give the information to individuals or the authorities to shut down the websites of the frauds who does any cybercrime to people, and if they does some malicious activities, it is their duty, the authorities duty, to protect the individual under this act. The criminal penalties and other restrictions of the law are serious threat to free expression in the nation. Also, there have been laid down certain punishments, very serious punishments, with seeing the increasing rates in the cyber crimes these days. There have many restrictions imposed. Several legal cases have been filed in the Supreme Court of the nation and demanded that this law be declared unconstitutional because it violates guarantees to free expression. But some people say that the Supreme Court should violate this law, as it completely hinders the freedom of speech and expression of an individual. Uh, mm, uh, a debate has been passed in the Supreme Court of uh, disadvantages of this act, that this act violates the rights of people and should be declared unconstitutional because it does not guarantee the free expression contained in the Constitution of the Philippines and human rights treaties ratified by the nation. We have reached to the conclusion of this video, and a comparison between the Cybercrime Prevention Acts and the policies of the Philippines and India shows similarities to some extent. And because cybercrime is a concept which is not only limited to certain states or certain boundaries, but it is a worldwide phenomena because the world is developing today, and the development is through the social media, which everyone, even a child, a lady, a woman, a household working woman, an old man or old woman, everyone is working socially using internet networking. And networking, it is clear, when there are certain benefits, it may lead to certain disadvantages or loopholes as well. And this act, in India, the Information Technology Act of 2000, section 66A, defines the penalty for sending offensive messages through the computer, mobile phones, or tablets. Because the government failed to define the term offensive, it began to be used to suppress freedom of speech. And recently, the government of India has passed the Digital Privacy Act, which protects the individual's right of freedom to speech and expression as well, and also the people of India from the cyber crimes such as sex, cyberbullying, or cyber squatting. Thank you. Thank you for hearing me.